We do this by creating content and organizing probably over 50 events and programs per year, educating and connecting startup founders, corporates, internationals, and many more. To find out more about us and the work that we do, and also how you can potentially partner with us, please check out our website at siliconvalleyforum.com. So the Startup and Venture Capital Club is a series designed for early stage entrepreneurs. And we do this in partnership with our wonderful partners at Hopkins and Carley, who are a Silicon Valley law firm who has a lot of experience working with startups, from the idea phase all the way through their exit strategy. So before we get started, just a few housekeeping items. If you have any questions throughout the program, please put those in the Q&A box located at the lower portion of the Zoom screen, and we will get to as many of those questions as we can. Everyone here was muted upon entry, and the program will be recorded and uploaded onto the Silicon Valley Forum YouTube channel. So I'd like to welcome all our speakers here today and turn this over to Brendan Lunn, who is a shareholder and head of corporate at Hopkins and Carley. So Brendan.
Thanks, Denyse. Good morning, everyone. As Denyse said, my name is Brendan Lunn. I'm a shareholder and chair of Hopkins and Carley's corporate department. Our firm is really excited to participate as a key partner to Silicon Valley Forum Startup and Venture Capital Club Series this year. It's particularly exciting to see that we have people attending this from Maine and Austria, so that's pretty impressive. I want to take a moment to share information about our firm and our corporate department. Hopkins and Carley is a full-service law firm with offices in San Jose and Palo Alto. We have over 70 attorneys that are geared towards working with startups, investors, and established middle market through all phases of the business lifecycle, including expertise in corporate finance, mergers and acquisitions, intellectual property, tax, corporate governance, branding and trademark, real estate, employment, business litigation, and privacy and data security. So basically, all of the service offerings that would be needed by a startup venture. Our firm also caters to high net worth individuals and their trusts and estate needs, as well as working closely with financial institutions. Frequently, it's important for founders of a startup to handle their trust and estate planning needs before the value of their business increases too significantly. We believe our clients enjoy working with us, and we certainly seen our clients. The Hopkins and Carley attorneys focus on understanding clients' businesses and operations and the technology behind so as to provide practical and effective advice. We are comprised of former big law attorneys. We try to streamline staffing with senior attorneys and partners billing at lower hourly rates than many of the junior associates at national and international firms. We look forward to working together with you guys over the next year. We've had fun so far and we'll continue to have fun. And I think you'll really enjoy our program today. You'll listen to three of our best attorneys, Chiara Portner, Chris Redfield, and Mitesh Patel. Thanks, everyone. Enjoy the program.
All right. Well, thanks for those kind words, Brendan. I'm Chiara Portner, and I'm a shareholder at Hopkins and Carley and the co-chair of the IP department. So let me share my screen here. All right. So first we wanted to talk about, give you a sense of a primer on IP, because we have a lot of clients that might come to us and say they need a patent, but it turns out they really need a trademark. And so getting some clarity there before, because you need to have your IP ducks in a row before you can commercialize your products. So I'll give you an overview of the IP rights now, and then I'll turn it over to Chris Redfield and Mitesh Patel. So first, patents they're inventions. They're new and useful products. You can think of patents, maybe an electric vehicle charging station or some battery technology. Patents are protected for 20 years. They take some time to obtain a patent, the prosecution period. And then after that period, once you have the patent, they will be published. So people will be able to see your patent and understand what it is. And then you can license it for that 20-year period. Now, the counterpart, the alternative to patents would be a trade secret. This is something that would really be protected for longer than that 20-year period. So the Coke recipe, it's something that you truly keep secret within the company. You use NDAs and other measures to keep that protected. Then there's copyrights. Copyrights protect original works of authorship that have to be codified or something tangible. So a book or an article, software code, song lyrics and recordings. And the term of protection depends on if it's written by the author or if it's work for hire under the Copyright Act, whether it's developed by an employee or a contractor. And then we get to trademarks and trade names and trade dress, which Chris and Mitesh will talk about more in detail later. Trademarks, they identify the origin, so you know who made the product. You can look at certain things and they're very unique. You know that it came from Nike because you see that swoosh there. Trademarks, you want them to be, again, unique and not generic, like escalator was a trademark and then it really became generic.
Hey, Chiara.
Now, yes.
Hey, Chiara, sorry. Do you mind clicking the presenter mode? It might be a little easier for the attendees to see the slide. Yeah, it's in the bottom right.
Right at the bottom.
Corner. Yeah, keep going a few more over.
One more.
There you go.
I don't see something that says presenter mode.
You just click that,
Yeah.
which you're on right now.
Okay,
Might just take a second.
there we go.
I think
All
we're
right.
still, so you're actually sharing your screen. I think you got to share the presenter screen, the one that's.
Oh, yeah.
You want to just stop the share and then reshare and then open the PowerPoint presenter mode, and that'll work.
So click share screen
Yeah.
Yeah.
and then click my slides.
Click the presentation. Like if you have presentation mode open, it'll open the presentation, the mode of the presentation.
Open it up again. There might be another way for us to do it.
Let me try this again. Did that work? Is that better?
There we go.
Perfect. Thank you so
Okay.
much.
All right, sorry about that. Okay. Can you see the slide saying founder issues? It's not.
No,
advancing on these.
it's your old slide. The first. We only see the first one.
Okay.
You just went back one, I think.
There you go. Now we can see it.
Perfect.
Okay, there. It's taking a minute for some reason. All right. Back to it. So getting your IP ducks in a row. You need to make sure the company owns the IP. First and foremost, that's your bread and butter. So if your founders are developing IP prior to forming the company, you still need to get the IP transferred into the company and properly assigned. You need certain assignment language and proper ownership terms to make that happen, usually with a stock purchase agreement and mention assignment agreement. If a founder's working for their former employee at the time or doing some moonlighting, you need to really keep a clear separation there and making sure there's no tainting from their former employer. Now, related employee and contractor issues. This is really critical. Again, for the company to own the IP, it becomes an issue in any financing or M&A acquisition to ensure that the IP has properly been assigned. Now, with employees, you can rely on work for hire, but usually we recommend a waterfall approach with a true assignment. It has to be a present assignment grant of IP I hereby assign. And then with contractors, assignment is always best as well. You know, work for hire, it sounds great, right? Everyone says work for hire and they throw that term around. But really, work for hire with contractors only works for 9 specific categories and not software. And a lot of clients are using that term and it just won't function, at least in the US, to transfer the IP to the company. Also, some issues, if you designate something as work for hire in a contractor agreement in California, the person will be deemed to be an employee. So moral of the story is assignment is best. Follow the IP, like follow the money, you follow the IP, make sure that chain of title is neat and tied up. Lastly, I want to just make a note of issues with any government or university funding. This is always a representation and warranty in any M&A transaction. They'll want to know if the government or a university has contributed any money or ideas or IP to the company's inventions or other intellectual property. The reason for that is because the government can take on broader rights. It's called march-in rights. The government can essentially demand in a license, even an exclusive license in certain situations if they've contributed to the IP. And if the university is involved, whether it's a professor or a student, the university IP policies always have to be reviewed as well because they will trump and control. They determine how the IP can be used, how it's owned, who's going to patent what. And those terms usually can't be modified, but in certain situations they can be waived in signed agreements. So you just need to be careful with the strategy if you're using any government or university funding. So with that, I will let Mitesh and Chris take over for the fun part once you have your product and branding things.
Thank you, Chiara. I wanted to start off for anyone who's not completely familiar with what a trademark is. Might be surprising some of the things that can be considered trademarks. So let's just start off with, obviously a trademark is a word. It's also a symbol such as a logo or a device. It can be a slogan. It could be a product or packaging design. And all of these things are intended to identify the source of a product or service and also to distinguish it from others in the marketplace. So there are a number of other non-traditional marks, which would include, for example, sound marks, scent marks, building designs can be trademarks, trade dress, I should say, same thing. Motion marks are also trademarkable and registrable. So in the next slide, we'll see sort of some different types of marks and their graphics. Google, obviously a word mark. You'll see the famous Audi symbol, logo. Diamond is forever is a famous slogan. And of course, the well-known wrap on Hershey's Kisses. And then Brown is actually registered for UPS trucks. And so they have done quite a good job in promoting that and advertising it and instilling it in the minds of consumers as a source identifier. So as Chiara mentioned, trademarks are key assets of your company. And in some cases, they're more important than patents or other forms of IP, especially in certain industries. And the reason for that is because they help consumers associate your products and services with your business. They assure consumers that you have a certain level of quality of goods, and they also create goodwill and brand awareness. So I often get this question, do I really need a trademark registration? And in the US, the answer is actually no, you don't absolutely need a trademark registration. And that is because trademark rights in the US arise from use of the trademark, and those are called common law trademark rights. But there are key benefits to having a federal registration. So federal registration provides a number of additional benefits, such as prima facie evidence of exclusive right to use the mark, jurisdiction in federal court to sue infringers, the ability for a mark to become incontestable on certain grounds, if you have substantially exclusive use for 5 continuous years from registration, constructive nationwide notice of rights and constructive use in all markets, and then increased damages and attorney's fees under certain conditions, and a remedy against importation of infringed goods. So Mitesh will also speak about other benefits of registration, such as the ability to use a registration to take down infringing apps in the App Store on Google Play, and also to register with Amazon, which is increasingly important. So unlike the US, in most other countries, rights arise from registration and the first to file a trademark application. So if you are doing substantial business outside the US, very important to secure registrations in important markets. So 3 things to keep in mind. Select your mark, make sure it's a distinguishable mark. Clear it, make sure no one else is using it, and finally protect it. The most important first step in developing trademark rights is to adopt a distinctive mark. And once you've chosen a distinctive mark, it's important to conduct a search to determine if your proposed mark is available for use and registration. So now you've chosen a distinctive mark and determined it's available for use and registration. The next step is to file an application. And once you've done that, you hopefully will obtain a registration, and it will be critically important to protect your mark through proper use and enforcement measures. Sorry, Chiara, can you go back to the distinctiveness? Select it, there you go. Okay, so this is kind of a fun chart to explain the spectrum of distinctiveness of trademarks. If you look to your far left, you'll see generic. Generic term is the thing itself. It's not a trademark. It is available for everybody to use, and an example would be thermos for insulated containers for hot and cold foods. Next on the spectrum would be a descriptive mark. Descriptive mark are those that provide information about the product or service, a characteristic or a feature, and give you direct information about that. And an example would be American Airlines, because it's an airline in America providing airline services, it's descriptive. Now, does that mean that you can never acquire rights in that mark? No. Yeah, sorry. Yes, you can acquire rights, but it has to be through substantial use and advertising, and substantially exclusive use and advertising. And American Airlines has obviously done that over many years. And next on the spectrum of distinctiveness, we have suggestive marks. And this is the category that most people's marks fall into. And suggestive marks are those that require a multi-step thinking process to arrive at what the good or service is. And an example of that would be Burger King, for example. You don't know exactly, well, it's a famous mark, but you wouldn't know by looking at it, not knowing that it's famous, that it is actually a restaurant. But it gives you information. You know that it involves burgers. You know that they're considered to be great. So that's considered a suggestive mark. And next on the spectrum is, and you're moving towards stronger marks and more distinctive and protectable marks here, would be Apple. Apple is a word that is found in the dictionary, but it's incongruous because it's used in connection with computers, and apples have nothing to do with computers. So considered an arbitrary mark. And then finally, on the right-hand side, you'll see the most protectable, most distinctive mark is a fanciful mark made up, and Google is the iconic example of that. So now, hopefully you have chosen a mark that is suggestive, arbitrary, or fanciful, and you're ready to conduct a search. Typically, we'll do 2 levels of searching. One will be the preliminary knockout scan, and you can do this in the US or internationally. We do it all the time for clients, depending on what their business models are. And a preliminary knockout scan is really just going to look at whether there are identical marks or very close marks. And then once we've sort of vetted that there's no obviously conflicting marks, we will move to an in-depth US search, which will look at other applications and registrations for marks that are also potentially conflicting. It will also look at common law marks, those that are unregistered, and business names that may be conflicting to ensure that there will be no seriously conflicting marks. Now, these searches are never 100% guaranteed that they will uncover everything, but they get you pretty close to 100%. So you now have cleared your mark. You've chosen a fabulous mark. You have cleared it. You know no one else is using it. And now you're ready to file an application. There are several different bases upon which applications can be filed. And the first one I wanted to mention is a 1B application based on an intent to use. And the reason why this is so important is because it can be very advantageous to be able to claim the filing date as your constructive date of first use, and that's assuming the mark goes on to register. So you have your business model, you haven't gone to market yet, you've chosen your mark, you haven't put it to use yet. And as you know, in the US, rights arise from use. This is the one time when you can sort of draw a line in the sand and say, I've filed my intent to use application, and that becomes my constructive date of first use for priority purposes, assuming my mark goes on to register. The other basis obviously is based on use, that would be under section 1A, and then foreign registrations. If you have, for example, a registration in the EU, you would file under section 44E. And the benefit of that is if you do file under a foreign registration basis, you don't have to prove use to get a registration. It doesn't mean you shouldn't use it. You definitely need to put it to use and would have to prove use within 5 to 6 years of registration when maintenance documents are due. And then finally, I wanted to mention international registrations under the Madrid system and 66A. So if you have filed an international registration, you can designate the US, and that becomes the basis for the application. So here's a little bit of a flow chart just to walk you through the registration process. You filed your application. It'll take about 3 to 4 months to get assigned to an examiner. And if an office action issues, an office action will issue if there are objections and the examiner needs clarification either on goods and services descriptions, or maybe he did find or she found a conflicting mark and wants you to provide arguments to persuade the examiner that it's not conflicting. You will have 6 months to respond, but times to respond are going to vary later in the year under the Trademark Modernization Act. So stay tuned for that. And so let's say you've gotten an office action, you've responded to it successfully, and now your application will publish for opposition purposes, and interested parties will have 30 days to file an opposition or an extension of time to oppose. And if no third-party oppositions are filed, and you filed your application based on an intent to use, a notice of allowance will issue, and you'll have 6 months to provide evidence of use of the mark and a date of first use in commerce or extension. And yeah. So statement of use is examined, and then if it's approved, a registration will issue, and typically it takes 12 to 18 months to registration, barring major objections. I know that seems like an eternity in Silicon Valley, where products can come and go in 12 to 18 months, but nonetheless, that's typically how long it can take. In the next slide, I wanted to go through some of the relevant classes, just to give you a sense when your attorney is talking about certain classifications of goods. These are some of the more common classes we see for tech companies. Mobile application software is in 9, online marketplaces would be in 35, telecommunications in 38, online gaming, for example, education and entertainment services would be in class 41, SaaS software services in class 42, and then in 45 would be social networking services. There's all kinds of other classes that cover different goods and services. Class 10, for example, would be medical devices. Class 5 would be pharmaceutical products. So this is just to give you an idea of some of the classes and what they relate to. And in this slide, I just wanted to talk for a second about use of other third-party marks. Basically, don't do it unless you've obtained authorization from the owners. And I know it's tempting, and people do it all the time when they have, quote, partnered with other companies to provide certain ancillary services, or their products are compatible with a third party's product or service. They will use a logo on their website. It's actually, you can't do it without authorization. So I just would encourage everyone to get that consent and authorization from third parties. And then finally, important to provide an attribution statement regarding the ownership of your mark, as well as any third-party marks that you have gained consent to use on your website, indicating that they are owned either by you or the third parties. And with that, Mitesh, I turn it over to you.
Sure. Thanks, Chris. Thanks, Chiara. Great summary of how trademarks work, how IP property can affect startups. We're going to real quick talk about trademark registration, kind of the importance of it. Chris kind of covered that and why that's really important to protect and enforce your brand. So really it's about obtaining maximum control, right? You want to basically make sure that you can not just defend your mark, it's a sword and a shield, right? You want to be able to make sure that you can have other people not infringe on your trademark in a confusingly similar manner, so that you are the exclusive owner of these rights, right? And this really is a business risk thing. Proper protection of your trademark allows you to utilize your assets more effectively, stopping people from using them to protect your goodwill, carving out areas so that consumers can recognize that these products come from my company versus a competitor. And so these are a lot of baseline kind of rules that come up. And we'll look at a quick example for the next slide of stuff that happens, when you have a weak mark, for example, right? So like GameStop, Chris talked about marks that are weak and strong, right? And it really relies on consumer perception, right? So GameStop, it's a game, that's what they sell, right? Stop, okay, well that's not necessarily a descriptive word. So that creates a mark that has this perception in the minds of consumers that say, okay, that's where I'm gonna go to buy my games. This looks very similar to a GameStop, but it's a game shop, right? And we see that sometimes words can be protected, like Chris said, logos and colors can be protected, like Brown has UPS, Reese's peanut butter cups, the orange packaging that's protected. Tiffany's, the teal on their website and stuff like that, that's protected, right? And these things, when you go to their website, you know that it's coming from them. So as a company owner, as a brand owner, I have certain things that consumers can recognize my product or service by, and those are my IP assets. Those things that are differentiable, I can hopefully protect if they're distinguished enough, and get those filed and protected. Once I'm protected for those, it's much easier to stop infringing uses versus trying to stop someone who's potentially registered and I sat on my rights. And Chris talked about there's two ways to file an application. There's an in-use application. Hey, USPTO, here's my trademark. Here's proof that I'm using it. Here's some pictures, on a website. Here's the date that I've been using it since, right? Second way to file it is intent to use. I'm not using it yet, but I'm gonna use it. And my priority dates back to that filing date, right? When we're doing this, important is really what else is out there, because how protectable my mark is gonna depend on one, how strong my mark is, right? If it's weak on that other side of the spectrum where it's descriptive or generic, it really can't function as a source identifier, like game shop, right? If that was a trademark, it's really just a shop where you buy games. It's hard to differentiate that from a source origination standpoint, right? And so from a trademark perspective, protecting trademarks really goes along with using them in a proper manner, right? Using them not as nouns, as verbs, never using them possessively or in plural unless the trademark is itself like that. And that's what creates that baseline of strength that you can then protect, or consistency. Because when brands are inconsistent, it makes it that much harder to protect them because they're not recognized as that perception of source, right? That single identifier of where this thing is coming from, because I'm using a bunch of different things. So it's that much harder for consumers to tell my product from a competitor's product, right? Some enforcement examples, going through to the next slide, Adidas versus Payless. We have Adidas. So growing up, for me, it was hard. My parents didn't have much money, so we always had the knockoff shoes. And I get made fun of a lot, walking off to school with the 4-stripe shoes. And I didn't know any better, right? But obviously, they're knockoffs, so Adidas claims. And this was one of the biggest jury awards at the time, at $300 million. This case took over 6.5 years. It was later reduced to $65 million, but this was huge, right? Adidas was able to protect the trade dress of these 3 stripes to show that when people saw these shoes, they knew it was Adidas. And these 4 stripes still conjures that feeling. People get confused that it's originating from Adidas, or maybe Adidas added a 4th stripe, right? Fourth stripe is better, just like the razors, extra razor, better shave. Who knows, right? So this kind of stuff gets confusing if consumers are buying that. I'm sure, when my mom went to the store, she goes, oh, these kids are wearing all these cool shoes. This looks just like that. I'll buy that for my son. He'll be the coolest kid around. Unfortunately, it didn't work out like that. But, it's the goal. Next slide, please. And so there's a number of ways that we're going to try to address online infringement. A lot of this is monitoring, right? If I have a brand, hopefully we went through the steps like Chris talked about to first select strong protectable marks that are not descriptive, right? Marks that are not generic, because then they are incapable of functioning to identify my services and distinguish them from those of others, right? So I must have a strong mark. If I have a strong mark and I can protect it, there's nobody else using it. I've registered it. Well, great. Now I want to watch it. I want to protect it. I want to look out for competitors, right? They're using similar marks. And when I use descriptive marks like Game Shop, a competitor might use that and they might be using it descriptively. So that's one of the things that comes when I'm using a trademark or when I'm using a word. Even if I'm just using, a lot of what we do for clients is sometimes, they'll do advertising programs and they'll send us advertising copy, packaging, so that we can confirm. We'll just do searches for some of the wording in there, the phrases, to make sure that there's not already registered trademarks for those things. Service that I'm using, a slogan, because even if I'm not using it as a trademark, I'm just going to put it on my flyer. That may be a protected trademark already that somebody else is using. So it's really important to clear these things before I'm using it, like Chris talked about. And that scope of clearance is going to depend on where you're using it, how I'm using it, right? Sometimes if I'm using something seasonally, I may not need to register it because it's only going to the product might have a lifeline for so long, right? But at the same time, if infringement is going to be an issue, I may want to start protecting that so that I can start, sending letters, cease and desist letters, takedown notices, and things like that based on my registered and protected rights. There was a question in the chat about, how do I protect a mark? If I have a mark that's protected and there's a junior mark that's registered, but I've been using it for longer, what are my options here, right? And that's a great question because that happens all the time. I have a trademark. I've been using my business, my company for a while. I'm offering goods and services. And like Chris said, in the United States, I get rights based on use. As soon as I start using that trademark, I'm establishing some kind of rights, okay? And it's going to be in the area, the geographic area that I'm using those rights. When I file a federal trademark and I get granted that federal registration, it's presumed to be valid across the entire United States. So think about that from a just using a trademark, you get the rights where you're using it. And if you're not using it everywhere, only where it's actually used. Versus filing it federally, it's presumed to be valid all across the United States. Much, much easier to enforce against someone in a state over or something like that when you have that registration, right? So it's really, and to stop someone who's registered without, and me not having a registration is going to be very costly. These things can very easily, and some of my colleagues who litigate these things can tell you, hundreds of thousands of dollars in a few months very easily, right? When we're looking online, you're going to look at keywords, you can look at e-commerce websites, kind of what areas that you're competing in, what other people are doing, and you want to monitor how people are using it. You can set up Google alerts for your company name, your brand name, your slogans. We offer trademark monitoring. Every time I file an application for a client, I strongly recommend to them, hey guys, we're going to file a trademark watch, right? We're going to order this watch that a third-party service, they will just look through, and every time somebody files a new trademark application that's similar to this trademark, they'll let me know. I'll take a look at it. And if it's something that I think we should be aware of, I'll let you know. And now we're alerted to this use way before maybe these people have even started using the trademark, right? So that gives us a bunch of options now. We can potentially write a letter of protest to the USPTO to make sure that the examiner does catch and cite our trademark as a basis to refuse this pending newly filed application. We can send them a cease and desist letter if we have active use that we find that they're using somewhere. We can take takedown notice if the use is online somewhere and it's already violating our registered trademark rights. So having a registration, very, very important to protect these rights. And not just protect them, but to enforce them, right? Next slide, please. And so this is what, when we talk about worldwide and country, it's the scope of my use. And all countries in the United States, Chris mentioned, we get rights based on using a trademark. That's not always true in every country. In some countries, I actually have to file a registration before I even, in order to get rights to be able to use the trademark there, right? Sometimes I have to have those rights solidified by the IP office in the country to sell goods in that country or offer my services in that country, right? And so this is on a country by country basis. Not all countries are like the United States. It's a spectrum, and most countries don't require use, unlike the United States. So you can't really squat on trademark rights here in the United States, unlike you might be able to do in other places. And that really gives a strong tool for trademark owners, because a trademark registration must be based on use, with some exceptions, for something that's, for example, based on a foreign registration, like Chris mentioned. But even those are subject to cancellation if they haven't shown use or used the mark a certain amount of time after registration, usually about 3 to 5 years. And so one of the other things we can do is when we're doing worldwide monitoring is really effective is file your trademark if it's for goods with Customs and Border Protection. And we've had great success with this. If you're experiencing a lot of counterfeiting, right, stuff that's coming in for a physical, tangible good product, widget, whatever it is, it's a great idea if you have, first step is get that strong mark, select it, clear it, right, protect it, file it and register it. Once you have it registered, you can file that registration with Customs and Border Protection, and they're not going to check every shipment that comes in, but it's a great way that you can have a third party now for shipments that come in, big ports of entry, Long Beach, New York. They will randomly check stuff, and if it has my trademark on it, they'll check to see. I also provide them my authorized licensees who are allowed to import these things, and if it's them, great, they just pass it on. If it's not one of my authorized licensees, they will actually seize those goods. They will contact me and say, hey, we found these goods. They look like they have your trademark on them. Let us know if this is authorized. They'll contact the person who tried to ship the goods or who's receiving them and say, hey, these are not authorized. We'll release them to you if you get the authorization of the trademark owner. And so now I have this person's information. I can potentially trace it back to figure out where these goods are coming from. And that's a huge, huge deal for me, because counterfeits, these things, when infringement happens, it affects my brand in a negative way, hugely, because a counterfeit product, if I buy something, it's counterfeit. I don't necessarily realize that. A consumer buys something thinking that they're getting the reputation of this product, the Apple AirPods, whatever it is, right? I take it home and it stops working. It doesn't connect to my phone. If I don't realize that it's not a genuine Apple product, I may write off Apple as a brand for the rest of my life, right? My dad did that with Chryslers, had a bad experience, his first car, will not buy a Chrysler ever again, brand reputation, right? And so these kinds of infringements and counterfeits really affect a brand's ability to act as a source identifier and make that consistent reputation in the minds of consumers. And so it's really in brand owners' best interest to not just protect their marks, file them, protect them, register them, but then monitor, right? See what else is going on out there. Send letters. Because if I'm not doing that, if I'm not monitoring it, I potentially lose my trademark rights, right? Kleenex, Chris mentioned Thermos, right? These were brands at one point. Kleenex is still a brand. They're trying to really make it so you're not saying, hey, grab me a Kleenex when you're talking about the Kimberly-Clark tissues, right? It's grab me a Kleenex tissue, right? And that's the proper trademark use. Velcro, right? Oh, Velcro shoes. Well, you should always use a trademark followed by the generic descriptive term, right? That's you're using to describe it. So it's like Velcro hook and loop fasteners, right? And Velcro they did a real good video. They're worried, as many brand owners are, about losing the brand significance, because people, we use Velcro generically to refer to any hook and loop fastener, that fastener. And to Velcro, well, that's bad, because then their trademark rights are eroded, right? And less. And so for them, great video, look it up on Google if you have a few minutes, Velcro lawyers trademark song. Really funny, but they're really trying to make the big effort to use the trademark properly so they don't lose their rights in it. Okay. Next slide. And so here's a great example of a historic kind of from Coke and Pepsi. And you see from late 1800s into the 1940s, these logos look very, very similar, right? And in 1942, Coke sued Pepsi in Canada. Unfortunately, they held, the court for Coke unfortunately held, well, hey, cola, that portion of the mark is generic, right? And that brings me back to my strong marks. If my trademark is San Francisco Roofing Company, strong mark? No, right? Because I can't stop someone from using San Jose Plumbing Company. Well, but they're using a city that's close to me and then whatever they're doing, which is just like mine. Yeah, but these terms aren't strong. They're descriptive. People are going to need these words to just describe what they're doing, right? And so I need to make sure that the cola, that those kinds of things aren't going to be strong, right? And the Pepsi and Coca, those were differentiable enough, right? If we go to the next slide, we can see the changes that the brands eventually started taking to see kind of what we have the modern look for now. But designs, words, all of these play a part in brands. And, Chiara talked about patents, copyrights, trade secrets, all of this stuff, the way consumers know that you have this cool patent and copyright is by your name, right? By the brand. And the brand really personifies all of your IP. It's the legal embodiment of your IP. That's how people know how good you are, your reputation, and so trademarks, they're really underutilized a lot. And so it's really important to protect them because the benefit you get is huge. Next slide, we'll talk about policing your trademarks, right? And so proper use goes hand in hand with policing. You want to use it properly. You want to make sure that if people are using the trademark, you have distributors or that you're licensing the right for them to use it, and there's strict guidelines on those licenses. Because if I am licensing my trademark to other people and I'm not watching or controlling the quality of what they're doing, that trademark no longer functions as a source identifier, which is the definition of a trademark, right? If it can't function as a source identifier, it's no longer a trademark, and I lose that protection, right? So I must police that. I've got to look for confusingly similar marks, and that's going to be a multi-step analysis. It's how close are the marks from a appearance and sound standpoint. Phonetically, do they sound the same? Are they for similar goods and services? Do they overlap? Could they be confusingly similar, right? It's a multi-step process. So it's not just a one factor will win the day. And that's why it's important to it's not like, oh yeah, I did a quick search and there's nothing out there. That's why, we're around. We can help you figure out what's out there. And there's no guarantee. We can't guarantee that this mark is available, but there's always going to be potential for third parties who haven't registered their rights, who now come up and say, hey, wait, I have a right to that trademark. I've been using it longer. And those trademarks might be limited in geographic scope because they haven't registered them federally, but that's something that I should watch out for by doing searches before I file a trademark, right? Next slide. Using trademarks, Lego is a great example. Lego started out with patents, right? And they had these bricks, they had these design patents, all these kinds of cool patents. And they would try to protect a lot of what they were doing by patent and copyright. Although eventually those things would end, right? Because those are, like Chiara talked about, limited in duration, okay? Trademarks last forever though, right? They're not using Harry Potter here because that's the trademark. They're not using Lego here because that's the trademark. This is a knockoff, right? You can't protect the functional aspects of things with trademarks, but you can protect the names. This is the Justice Magician, right? Harry Potter. Next slide. Right. Star Plan, or if there's Star Wars, right? And these are great because Lego is a great example of great trademark use, because Legos, they realize that, hey, trademarks are the way that we're going to be able to protect ourselves. And so that's what they're doing, because they're extending their brand reach from what they're doing. But trademarks allow you to not just use your brand for what you're doing, but these other things, right? Like licensing, Star Wars, right? Harry Potter. These are licensing revenues, movies. Lego is great at doing all this other stuff related to their core stuff. And the reason they can is because their assets, their brand has a licensing value that other people are willing to pay for it, and that they can control the quality of that. Hugely, hugely profitable for a company to have something like that, right? Next slide. And so really this comes down to, name of the game is select strong marks, right? Strong, protectable marks. Not the weaker the mark is, even if I'm using it for a long time, it's gonna be much harder to then not only protect it, right, defend it, but also stop other people from using a similar mark. Clear those marks. Make sure there's no one using a similar mark out there. Make sure there's no negative connotations to that mark in a different language or a translated term. Make sure the domains are available, right? Clearing a mark has a very many different aspects to it. It's not just, okay, well, the trademark is not, it's no one else is using it. Well, there might be a reason, right? It might be descriptive. It may not be registrable for some reason. Clearing a mark worldwide, domestically, a lot of different scope that you can take when you're doing that. And then finally, if it's clear, protect it, register it. That way you can then use that registration as not just a shield, but also as a sword if and when you need it. And that's what I've got. Unless anyone has any questions, we can go through. I think there's a few questions in here. So third-party marks, best practice, tuck the logo, consent, purchase order, statement of work. If you do work for a company, add them. So Ralph, I'm not quite sure what the question is, but if you can follow up with that, I'm happy to answer that. Second question is, if someone has the same trademark but didn't register it before I filed an application, am I allowed to continue using the mark? So that great question. So that's going to depend, right? If I'm using a trademark and I haven't registered it, and I come across with somebody who is now filing an application for my trademark, it's going to depend on priority, right? Who started using it first, and can I evidence that? And it's very important. I talk to clients all the time, well, hey, we want to stop this guy from using it. Okay, well, great. When did you start using it? Like 20 years ago. Show me how. Like, give me some evidence, right? Well, this is our website. We have a way back archive, or I have my first flyer. Keep these kinds of evidence, right? The first time your invoice is sold, with a mark on it, email correspondence, putting up the first website, that may not be evidence of trademark use for USPTO purposes, but it can be great evidence of use to protect and enforce your rights from a priority perspective, right? So it's great to keep all this kind of evidence of how you're using it in line and really organized. So that way, when you do talk to somebody about this, you can give it to them right away, right? Chris, Chiara, anything to add?
Yeah, Mitesh, I just wanted to add on priority. If somebody has earlier use, their use may be restricted to a certain geographic location where they actually sold those goods. So if they're selling only in California, their rights would really only apply to California. If they're selling in a number of other states, then they would have rights in those states in terms of common law rights as well.
Absolutely right. And a lot of that is geographic. That's where it rights in the United States, based on wherever they're using it. There's Burger King. There's a small little Burger King somewhere out in the middle of the United States that was before the Burger King we know, right? And Burger King has federal rights. This small little restaurant had rights predating the Burger King we know, but they have the rights in the area that they are. They can't expand beyond that now, but Burger King can't stop them from using their rights because they predated Burger King's rights.
And the other thing I wanted to mention too is trademark rights can go on forever, like Mitesh said. However, you need to file maintenance documents between the 5th and 6th year of registration, and also declarations of use and renewal applications every 10 years. So as long as you do that, your trademark should last as long as you pay those fees and submit evidence of use.
Yeah, and like Steamboat Willie, great example. Disney has been lobbying copyright for longer and longer protection. They realize this can only last so long. The Steamboat Willie, the first iteration of one of Mickey Mouse and Steamboat animations, it was copyright's expiring. What do? They throw it in front of Walt Disney Animation, before the movie starts as Steamboat Willie, and he's sitting there whistling, and they use it as a trademark. And now, as long as they continue to use it and renew it, that's forever, right? So exactly.
So there's a question: if you're only operating in your state, does it make sense to get a trademark registration, a federal registration, since you have common law rights? So if you're only operating in one particular state, it would be a good idea to get a state registration.
Yeah, and it depends on what kind of business I'm operating. If I'm selling sunglasses in the middle of Wisconsin, I probably am only going to be use in Wisconsin. If I'm selling sunglasses at McCarran Airport in Las Vegas, I think that could probably be interstate commerce where I could apply for a federal trademark, right? So it's going to depend on where I'm doing, what I'm doing, if I'm using channels of the interstate commerce online, right? A lot of different considerations. Definitely talk to an attorney.
And the reason for that, just to add to that, is because you've got people moving through the airport that come from other states, just to clarify.
Thanks, Chris.
And also on the trademarks are geographic, like Mitesh and Chris have discussed. Going back to just buttoning up your IP and ownership of the company, all those rights and getting the proper language to have the IP transferred and properly owned by the company, they are geographic as well. We recently had a client, they had hired some Ukraine developers, and they had used a US-based agreement, which had the US proper language, but they didn't use language that actually works in the Ukraine to have the IP transferred properly. So it all depends on where the employee or contractor is located.
And you don't need to, Daphne asked when we register a trademark, do we need to specify the geography? No, by filing a federal trademark application, I'm filing for federal protection across the United States. And if I get registered, it's presumed to be valid across the United States. If it ends up being that I didn't actually use it across the United States, someone can challenge those rights and potentially limit those to where I actually was using it.
Any more questions for the panelists? All right, I think that wraps it up. Any Chiara, any Christine or Mitesh, any final words?
Thank you all for coming today. And if you have any follow-up questions on trademarks or copyright or any way we can be of assistance, we would be happy to talk with you about your needs.
So Chiara, I believe you mentioned that a copy of the deck can be available for those who want it. Is that correct?
Yes, we're happy to send that out.
Okay, excellent, excellent. Well, thank you so much to all of our speakers. Great presentation, got so much information. Because there's so much information, I'm sure, you know, a lot of it wasn't completely absorbed in this 1 hour. So this program has been recorded and will be sent out to all the attendees today, and also the copy of the deck for those of you who want that as well. So thank you to everyone who joined us this afternoon, or for those in Vienna, you know, it's evening time. So thank you so much, and hope everyone has a great rest of the day, great evening, and we'll see you next month for the next program and our Startup and Venture Capital Club series. So, bye. Thank you.